Hapana, wacha kuharass the accused person mbele ya court. Mask, it is a national obligation. Hey, no. I'm an advocate out of this court and I can tell you for free. Nyinyi sasa mmeisha nyinyi witnesses hapa. Mkuze tena. This fellas the way they want and again, this person has a right to have an advocate. You asked him to be in court and he did not leave this court. The court is sitting. And you brought him yourself. And you don't do anything to it. This is like a democratic society. Don't harass this young man. I now sit here with him. Thank you. And we offer him solidarity. Due to the nature of public interest that it has attracted, there is a lot of confidence in the institution. I particularly received those factors just as some matter is we had a very short time to report statements, seek the relevant staff reports, and also present the file to our office for registration. Consideration of registration of the church, therefore you know he has not had time to take an affidavit of election form, which is the resolution is we objecting to the person being granted one. In my mind, it's pray for 3 minutes. To allow the eye to put in the supplement. Explaining the issues of voting and that.
Yeah, that's it.
She has rights.
They will not harass this man in this court. Let him take the police station.
Don't be biased.
So we give you amenities. Okay.
Count 1, robbery with violence, according to section 2962 of the Penal Code, particulars of the offense, on the 2nd day of June 2024 at Community Road in Kasarani County, Nairobi County, jointly with others noted for court, road number 67839, Koplo, Jaffo, Ogendo, battery of police communication gadget and a mobile phone made Samsung Galaxy Note 1 valued at Kenya shillings, 50,000 shillings, and immediately before or immediately at the time of such robbery wounded the said number 67839 Corporal Jacob Ogendo. Njoroge. Is it true or not true?
Honorable Kimaru, Honorable Mutuko said this, and I'm giving a copy to the court declaration. We are going to declaration and order. We hereby declare that section 296 295, page, Your Honor, it's page 42 of 43. Page 42 of. This is what the court said, High Court of Kenya, sitting in Nairobi and not even in Kisumu. We hereby declare that section 296, 295 and 296 to 297 1 and 297 2 of the Federal Court do not meet the constitutional threshold of setting out in sufficient precision, distinctively clarifying and differentiating the degrees of aggravation of the offense of robbery and attempted robbery with violence, such particularity as to enable those accused to adequately answer the charges and prepare their defenses. They go ahead and say, in light of one above, we recommend that the Attorney General, the Kenya Law Reform and other relevant agencies to prepare detailed professional review in the context of judgment and order made in view of enabling Parliament to appropriately amend sections 295, 296, 1, 296 to 297 1 and 297 2 of the Federal Code with a view of removing the ambiguity. Walipewa nafasi waende waondoe dosari, lakini wakazembea kotini, wakazembea kazini. Maafisa wa serikali, they are now the same men preparing charges. And I don't know whether my sister will talk to the ODPP on this particular charge. This is what the court held recently. In view of the fact that there are pending trials before the court of various stages of hearing processes where the accused persons have been charged with.
Until tomorrow, wherein we expect that they file the intended affidavit in the position of the accused person being released on court. So I'll give them 1 day. We come back tomorrow, and then we can argue that application tomorrow. More of it has been argued today, must agree, yeah? But you can buttress it tomorrow once we have that affidavit. Because I think it's strike law, and I think it's, you have rightly pointed out, without those cogent, very formidable grounds, the court cannot continue detaining the accused person. So let's wait until tomorrow we see that affidavit, and then we can argue the same tomorrow. So I'll not grant them the 3 days they are sought, I'll grant them only 1 day. So we'll come back tomorrow for that, yes.
Can we convene the same at 12? Because I know it has to be still taken to our office because of procedure. So in the morning they submit.
You want to just one more thing in protection of the intended accused person, because he has not taken plea. You want this morning we had drama in this. He has taken place. Sorry. In this morning we had drama in this court before you entered.
Okay.
The police officers who accompanied him attempted to assault him when he was seated with his advocate, and I had to physically intervene as his advocate. So as you send him back to them, Your Honor, favor us with a statement that his rights must be protected. His body has scars all over, and we are afraid that this 1 day you are granting them may make a difference.
Your Honor,
and they should take him to hospital for that matter.
Yes, as a follow-up, Your Honor, and actually that's what I wanted to mention. Your Honor, now that you have wisely given your directions, the accused person has injuries, as you've been told. And I don't know the aspect of the personal items. I don't know if we deal with them tomorrow, because we've taken some.
Yeah, I think let's deal with them tomorrow. And also, just to underscore, that we have to protect his right as well. Yeah. So I think you've elucidated the content of Article 28, 27, and also the right of an accused person. Yeah. So I think for all the agencies involved, kindly let's adhere to our constitution. Yeah. So that we don't aggravate the situation as it is. I'm not allegedly aggravate the situation as it is. So let his right be protected. Let me hear from the other team whether on the issue of being escorted to hospital. Kenyatta. Okay. Escorted to Kenyatta, and then he should be accompanied by a parent, and also at all times he should be given access to his counsel, yeah, so that we can curtail or stop any any form of an injustice towards him or infringement of his right. So then he'll be remanded at that industrial area. So meet tomorrow at noon then.
Thank you.
Okay.
Taken aback by the application made by the prosecution this morning. Your Honor, this is the first time in Kenya's history that a court is being requested to declare that the inability of giving an affidavit or performing an affidavit by an investigation officer becomes one of the compelling reasons to deny an accused person bond. It has never happened, not even in Uganda. Your Honor, what is a compelling reason? Your Honor, is something that has been exhausted and has gone all the way to the utmost course. Not only has that happened, but even the bail bond policy that my sister is guided, that is their Bible as a DOP, is very clear on what is a compelling reason. And the aspect that an officer has not been cannot be a reason for a court to detain, to order for the detainment of an accused person for even a minute longer, Your Honor. That will go into the history books. If this court, that is what you are being invited to do. And what will happen, Your Honor, if you allow that door? If you open up that door, Your Honor, I very respectfully submit. Your Honor, nothing stops all other investigating officers from always coming to this court and all other courts and abusing that and saying, we did not have time. Detain this person for 3 days. Now they're asking for 3 days, the next time they'll be asking for 14 days on that reason, which is not in our constitution. And Your Honor, I'm sure if it wasn't for the fact that my sister was called out, that's not a reason that she would have actually given. She was not prepared to oppose for it. But someone has just called her, used this reason, unfortunately. But we are happy, Your Honor, that the Constitution empowers you to uphold the rights of even Lucifer himself or herself, I don't know the gender. If Lucifer was to stand on this particular matter, Your Honor, the Constitution still says that person remains innocent until proven guilty. And the right to bond, Your Honor, can only be curtailed when they have told you, even if it would have been off the back, that this person is at flight risk. Would not attend court. Can
interfere with witnesses. I do not wish to regurgitate that, Your Honor, because you know it better than myself. And to that extent, Your Honor, it is our humble submission before you has been brought before you. Your Honor, there have been grave violations. Your Honor, within a second, I will just play a very small clip that has been posted by the police within 1 minute, just for you to understand what they are saying.
It is 2 phones and a laptop, and these are good phones. They also took his ID, and because we do not expect them to conduct any forensic examination on these gadgets, they should return them like yesterday. The laptop, HP-5, HP-5, is a school gadget. It's a student that is in no doubt has produced documentation that should be given to him. Your Honor, on the submission under Article 29, I wish to add that this particular article is one of the articles under Article 25 that is not derogable. So that a policeman who has already characterized this young man as a dog is only expected to treat him as a dog when he has been given more time, or once these court sanctions that they detain him longer. Article 28, my Lord, Your Honor, is on the dignity. What my good colleague and brother has played here is very clear that they do not want, they just want more time to continue torturing this young man. When I was a student of literature, I used to call them this God is of you. Now, on to the first count, Your Honor. The first count, and then it has been put there maliciously. Robbery is violence, and we are going to demonstrate the particulars of malice. Your Honor, in Joseph Kaberia Karinga and 11 others versus Attorney General, 2016 EKRL, Your Honor, to be compensated for having been charged with a law that does not exist. Your Honor, the advocate who argued this case happened to have been my friend, Evans Wilkie. Until this morning, when we learned that the police are concocting this particular charge, told me that they have not even bothered to apply under 5(2)(b) rules of the Court of Appeal to suspend this. So as you sit there, as we stand on this side, there is nothing like robbery with violence under section 296(2) of the Federal Code of Kenya. Watume maabara yao waende wakatengeneze sheria, waende wakatafute makosa mengine dhidi ya huyu kijana. Tafadhali tunakuomba tuende kusikiliwa, tumwachilie huyu kijana kwa even on his personal bond, ile tunaita personal recognizance kwa lugha ya kikoloni ama Kiingereza. Tunakuomba tafadhali, hakuna sababu zote ambazo zimetolewa. Tunaambiwa kwamba kulikuwa na umati katika kituo cha polisi mahali walipompeleka huyu kijana. Kama polisi wanaweza kwenda mtaa wote Nairobi wakiwa na vitoa machozi na kuwafukuza ama control the crowd, that is not a compelling reason. That in a police station like Kasarani, or a police station like I'm told Kasarani Stadium, that the crowd prevented police officers with guns, with sniffer dogs, with tear gas, with handicapes, and with their very intimidating uniform to swear an affidavit. That, as my good friend submitted, is an admission of lack of seriousness. So therefore, Your Honor, the only, if you are minded to release this young man on a cash pay, we pray that it be, you disregard the first account because that should not count. That one is gone. The only thing that you should actually consider is if actually, I don't think there is anything to consider. And they need him to flee personal bond. Aende nyumbani wakasome, wazazi wake wako hapa, si Mtanzania, si Uganda, si Mkongomani, ni Mkenya ambaye wanajua mahali yake. Usiwapatie mtu mwingine wowote kwenda kumuita huyu kijana huko. Umesikiza na masikio yako wewe mwenyewe. Kwa hayo machache, kama una swali,
is to be tendered by way of affidavit. That is our Evidence Act. Section 111 of the Evidence Act, Your Honor, says that he who avers must prove. The state has made wild allegations of crowds forming in police stations without any proof or pretense to that effect whatsoever. Your Honor, the accused person before you is 19 years old. He was brought here by 21 armed police officers. The number of police officers who escorted him are more than his age. These police officers, Your Honor, if they had time to sit down, they would have produced an affidavit before you. You cannot come to court 21 people to say that one individual will not sit down to craft a 5-page affidavit. He is a victim of state indolence, laziness, misconception of the law, and inefficiency in the police force. The state must not benefit from its inherent laziness. Having said that, Your Honor, I'll give you 2 authorities so that when you retire, you consider them. It is our trite law that when you are making an application to deny bail or bond, you give cogent evidence and not mere allegations. That was the position of the High Court sitting in Mombasa in criminal case number 26 of 2008. What the prosecutor has done is what the High Court warned, that mere allegations cannot deny an accused person his right to liberty and right to be admitted to bail. And lastly, Your Honor, when you look at the charge sheet, is a poorly crafted play that is to be watched by yourself and then be convinced that crimes of serious magnitude were committed. A 19-year-old robbing a mobile phone and a battery from an armed police officer. It's one of the worst plays to be played in our courts. In R versus Salim Said Nasoro, criminal case number 351 of 2016, in a High Court in Milimani, court was very clear that seriousness of the offense per se is not a reason to deny bail. Even if they are to charge him of murder or attempted murder, to make the offense appear serious before unsuspecting court users, it would not have been enough to deny him bail. Therefore, pray, Your Honor, that you consider the state, including the prosecution, not to have tendered anything before you, what determination, for the reason that there is no affidavit on record, even a poorly drafted one, to demonstrate that they lacked time to do a proper one, and proceed to have the charge sheet in its present ridiculous form read, and the accused person admitted to reasonable bail terms. Rest my case.
Those things that have been submitted on speculation, and not to, for the court not to put reliance on the same. Also being the issue that we will see for 3 days, then another 14 days, and is this next speculation? You know what has been said by the three council, and I will tell you, is that Your Honor, there is need for urgent evidence for us to move the court to the application to what they're not telling the court, it has been decided that this can only come through an affidavit. I cannot make submissions from the back seeking for position from you. And this is the very reason I'm before you, when seeking time and being given reasons why the IO did not have time. It is reasonable. And also to dispute the fact that he was not arrested on Sunday yesterday, as reflected in the charge sheet on the third of June. Your Honor, as to the issue of the affidavit, the defense are claiming even before you today that we do not even have an affidavit to the issue why we are innocent. It's an admission and it's clear that we do need an affidavit, which is the time we are seeking to put in support of our petition, so that once we are putting the affidavit, the issue of bond can be canvassed. On my next tip that has been taken before you, where they are claiming that they keep asking for the emotions, the display of emotions of one pastor does not speak for the entire National Police Service. And also, Your Honor, they were disputing the issue of crowd. Yet, to their own admission, they said the accused person has been brought to court by 21 police officers. That is not normal. It's only circumstances that call for that is when there's the need for such a security. The state does not intend to be denied for this person. We are here for a fair trial. We will be given that. We just wait for time to put in our affidavit. And lastly, to the issue of the charge of the very violence. If there is any mistake to the charge, there is recourse under Section 214 of the CPC. And I am well informed by my co-counsel, Mr. Shota, that there is a High Court petition ongoing regarding the faith charges. And that will be